Thank you again for joining us today for the CILA NILA webinar, Litigation for Unaccompanied Children, Updates and Foundational Cases. This webinar is the 7th in an ongoing series on litigation updates. My name is Serena Bhatia, and I'm a senior staff attorney at the Children's Immigration Law Academy, or CILA for short. We welcome you to say hello in the chat. You can click on it so that it says to panelists and everyone, and you can include your name and your organization or firm. We are again grateful for you that you are here with us today for this webinar. To get started, there are a few housekeeping matters that I would like to cover. First, if you have questions, please use the Q&A function rather than the chat box to submit them. We will have a few minutes at the end to go over questions. This training is being recorded. CILA will post the recording on our website in the next couple of weeks. You should have received PDFs of the slides and handouts this morning. We will email them again following the training. A couple notes regarding CLE credit. So the ABA will seek 1.5 hours of CLE credit in 60-minute states and 1.8 hours of CLE credit in 50-minute states. Credit hours are estimated and are subject to each state's approval and credit rounding rules. Please visit the ABA website on MCLE for general information on CLE at the ABA. You must attend today's training in full to receive credit, as partial credit will not be provided. Please note that during the training, we will verbally provide a CLE code. After the training, we will email you a CLE attendance confirmation form for those who would like to request CLE credit. ABA MCLE will seek credit on your behalf, assuming your attendance can be verified. On that attendance confirmation form, you'll be asked to verify your attendance at today's complete training and to provide that CLE code that was verbally provided today during the training. Again, you must complete this verification process and that form, and we also must be able to verify your minutes of attendance on our Zoom report in order to be able to request CLE credit on your behalf. And finally, we will seek your feedback at the end of today's training. A survey will automatically open once the Zoom webinar ends, so please do take a brief moment to let us know what you thought of today's training, as well as ideas for future topics for us to cover. A brief note on who CILA is for those of you who may not be familiar with us. Just a brief introduction. We are a capacity building organization and a project of the American Bar Association. We are based in Houston, Texas, though we have expanded many of our services to a nationwide audience. We provide technical assistance regarding case-specific questions relating to children and youth with immigration cases. We offer 5 national working groups and 1 Texas-specific working group. We provide trainings and written resources for practitioners working with unaccompanied migrant youth, and we host a platform featuring pro bono opportunities across the country and provide resources related to pro bono assistance. Now, an introduction to NILA, the organization, by Trina Realmuto.
Thanks, Serena. Hi, everyone, and welcome to this webinar. Thanks to CILA for hosting it. For those of you who aren't familiar with the National Immigration Litigation Alliance, I'm going to give a 2-minute quick overview of what we're about. My apologies to people who have been on these before and have heard the same spiel. We're a relatively new immigrant rights organization. We have 3 core programs. One of which is impact and transparency litigation. You'll see on your slide the types of litigation that we bring. Those are primarily class action lawsuits and lawsuits under the Freedom of Information Act seeking documentation that we put on our website and is hopefully publicly useful to practitioners. We also have a co-counseling program whereby we do individual immigration cases with practitioners who would like to litigate in federal court, who may never have done so before, or who have done so before, but maybe not on the type of case that they want to bring. And so it runs the gamut. We do everything from petitions for review to habeases to damages claims to district court actions and to delay actions. We also have a membership program whereby we provide strategic assistance and pleading review to our members. So it's an annual fee, and we can meet with you as much or as often as you'd like to discuss your case. If we can't answer the question, we put you in touch with someone who can. And for our members, we do have a pleading review program. So we'll review a federal court complaint or an opening brief or whatever it is. We also review BIA appeal briefs and motions to reopen if we have the expertise in that area. And we offer discounted rates on our webinars. Our practice advisories and template pleadings are available on our website, some of which we have issued in collaboration with CILA as a part of this series or earlier trainings. And so with that, I will pass it to the next slide.
Thanks, Trina. Here we go. So we also wanted to provide some more information about our partnership, since the CILA NILA partnership is a very unique and collaborative one, and we are now in our 3rd year of this partnership. So through this partnership, we provide trainings such as this one, as well as resources. And as mentioned before, CILA offers technical assistance. And if the questions are related to appellate and litigation practice, CILA is able to coordinate with NILA to answer those questions and provide guidance. And then CILA's website is also routinely updated and hosts a lot of helpful information. So if you are interested in learning more about those, we encourage you to check out the website at cilacademy.org. We wanted to provide an overview of the many trainings and written resources that we have produced through this partnership. And so these are all listed on the website, and they are all housed on CILA's website under trainings, as well as the appellate and litigation strategy webpage. With that, I am very happy to introduce our speakers for today's training from the National Immigration Litigation Alliance. And our speakers today are Trina Realmuto, the Executive Director of NILA, Mary Kenny, Deputy Director of NILA, Chris Rickard, Special Projects Attorney, and Aidan Langston, NYU Public Interest Fellow. Thank you all so much for presenting with us today, and I will hand it over to you all.
Great, thank you, Serena. I'm going to start us off by talking about a fairly recent delay case that came out of the DC Circuit Court of Appeals. And this case involved a claim of delay by some non-citizen investors. And I suspect that no one on this call handles employment-based investor visa petitions. But we wanted to raise it for 2 reasons. One, because it's one of the few Court of Appeals decisions that talks about delay, APA and mandamus delay actions in the immigration context. And 2, because, and so for that reason, the government's going to rely on it. Unfortunately, it's an unfavorable decision, and I'm going to talk about sort of what the court held. But the government's going to rely on it. And for those of you who are bringing these types of delay cases, you want to be prepared to address it. That's one thing. And the second thing is that a number of district courts will probably look at it also because it does a fairly deep dive into the track factors. And those are the factors that are based on the case Telecommunications Research and Action Center v. FCC. It's an old DC Circuit case that laid out approximately 6 factors that courts around the country use to analyze whether a delay is unreasonable for purposes of a mandamus and APA claims. And so here the court did a fairly deep dive into those track factors, and in particular 3 of them, which I'll talk about, and in terms of immigration cases. And that, again, will help you think through how you might distinguish your case, how you might really build a case for delay that you may overcome. If you're in the DC Circuit, you're going to be bound by this precedent, and you're going to have to overcome it and distinguish it. If you're outside of the DC Circuit, then you're just going to want to argue why this circuit should not be considered by the court as persuasive in terms of before the court that you're in. So the district court ruled in favor of USCIS, and so it was the plaintiffs. It was a consolidated appeal from two sets of investors. They appealed to the individually in each case. They appealed to the Court of Appeals, and the DC Circuit consolidated those appeals, and it really focused in on it focused in on particularly two of the trap factors, and they're the ones I'm going to talk about. The first is what's called the rule of reason, and it says that a court should look at whether or not there's a reasonable basis for the operation, for the processing operation of the agency, for the manner in which it handles whatever it is that's before it in immigration cases, its applications or petitions, and whether or not that process is reasonable. And here, this involved essentially the statute for employment-based and family-based petitions. The statute says essentially that those petitions, USCIS should deal with them on a first in, first out basis. And that statutory site is 8 USC 1152 E1. And there's a twist on it for investor visas. USCIS looked at the fact that getting an investor visa is a two-step process. You get the petition, and then you have to file an adjustment application, and the adjustment application is going to be dependent on whether or not a visa is available from the country in which the investor, the country of origin of the investor. And so from those countries that are oversubscribed, in which the priority date is not current, USCIS said, well, we can approve we can adjudicate the petition, and if we approve it, it's just going to sit there, and that investor is not going to be able to do anything until the visa becomes current. The visa numbers become current. And as a result, it determined that a more efficient way to handle these petitions would be to first prioritize those countries in which the visa numbers were current. And within those countries, they would then follow the statute and do first in, first out of the filing date of the petition. And then they would wait on all others until the visa number became current. And so the plaintiffs in this case challenged that the visa number was not current in their particular country. And they also argued that USCIS wasn't actually even following that process. But both the district court and then on appeal, the Court of Appeals rejected those arguments and found that it was absolutely a reasonable method for USCIS to follow. And second, that there was insufficient evidence by the plaintiffs to demonstrate that USCIS wasn't even following its own guidance with respect to how it was said it was processing these petitions. And so for that reason, it found that the first factor weighed, the rule of reason factor weighed heavily in favor of USCIS. The second factor that it really dove into was this factor that had to do with whether or not the effect of expediting an adjudication in a particular case, what impact it will have on the agency's other priorities and its other activities. And the court looked at that not so much in terms of the other priorities of the agency, but in terms of the other investors who were waiting for their petitions to be approved and who may have filed earlier than these particular plaintiffs. Many of them had. And it essentially said, these plaintiffs should not be allowed to jump in front of all of those others who were in line and who had been waiting longer. And that's a argument that some district courts have bought over the years. Those other district courts around the country have rejected. It's not an argument that any other court of appeals has yet addressed. And so it's unfortunate that there's now a court of appeals decision that's accepting that argument from USCIS as a legitimate argument. It's if you are facing this, you want to look at our practice advisory, which you'll find on our website. Immigrationlitigation.org is the website. You'll look for a practice advisory around delays in immigration petitions. And we cite a number of cases where the judges have rejected that argument and pushed back on it. And then the final thing that the court here looked at was that in this case, the plaintiffs had failed to show sufficient individualized harm. In one case, the only harm was financial, and the track factors make it clear that financial harm is not as important as harm that goes to an individual's health or welfare. The other set of plaintiffs in the other case did raise health and welfare harms, but they were generalized to the population. They came from a town in South Africa, and they talked about the problems in the town that they were trying to flee, but they didn't tie it to anything that they had personally experienced. And so the court rejected it on that basis. And so some things to take away from this are that you should be prepared to distinguish this case factually and legally. And factually, it's important to try to poke holes in any kind of reasoning that the government provides for it following an orderly process. And certainly with respect to other kinds of applications and petitions, there is some evidence out there that it doesn't follow any kind of real systematic or orderly process. And then second, harm. Look for individualized harm to your plaintiff and really focus on that. And that to the degree that that exists, that's going to make your case much stronger. Thank you. I'm going to turn it over to Trina now.
Thanks, Mary. So I'm going to talk about two cases now, one from the Supreme Court and another from the Board of Immigration Appeals that have, as we get into it, some of the same concepts about claim processing versus jurisdiction, which is sort of a hot topic in immigration these days. That was brought on, I think, first by the Nice-Chavez litigation, but has been around for a really long time. The first case I'm going to talk about, the slide on your screen is actually the Fifth Circuit decision, but I'm happy to report that it has been overturned. But I wanted to put the slide up here to give people a little context before we get into talking about the Supreme Court's decision in Santos-Zacaria, because I think it's helpful to understand how the case made it up to the Supreme Court before we talk about what the Supreme Court held. So this is the case involving a woman, Santos-Zacaria, who experienced as a child a rape that constituted past persecution. And her persecution was also sort of based on sexual orientation. But the board denied her withholding application on the ground that she had failed to demonstrate future persecution. And so even though counsel for Ms. Santos-Zacaria had asked the board to remand the case to the IJ for further fact-finding on that issue of future, whether the presumption of future persecution had been rebutted, the board in that case went ahead and they addressed it in the first instance. And so Ms. Santos-Zacaria filed a petition for review with the Fifth Circuit. And the Fifth Circuit refused to hear the petitioner's contention that it was wrong for the board to go ahead and decide that issue of future persecution and to do that fact-finding in the first instance without first sending the case back down to the immigration judge. And they refused to review this issue because they claimed that it had not been exhausted. Because at that time in the Fifth Circuit, they had this wackadoodle rule that you had to first raise this claim on a motion to reconsider to the board, and the board had to first decide it before the Court of Appeals would review that issue. And so the Court of Appeals said the issue wasn't exhausted, and that they couldn't review it under the statutory provision. The INA site is 242D. The federal code site is 8 U.S.C. 1252D. And so what happens next is that Santos-Zacaria's counsel files a petition for cert. Can we go to the next slide, please? And cert is granted by the Supreme Court on two questions. The first is whether or not that exhaustion provision is jurisdictional or claims processing rule. And the second is whether or not the person is required to have filed a motion to reconsider. So I want to talk a little bit quickly about sort of the rationale of those questions and how the court reached the outcome. And then I'll talk a little bit about the key takeaway points for practitioners from this decision. And admittedly, overall, this is the decision that affects people who file petitions for review. But at least with respect to the first question, I think some of the analysis is interesting and helpful. So on the first question, whether or not the statutory provision of the INA is jurisdictional or claims processing, the court comes down and holds that it's a claim processing rule subject to waiver and forfeiture. But before we get into that, I think it's helpful to just briefly mention the distinction between these two terms. When a statutory provision or a rule is jurisdictional, it's very rigid. It must be complied with. This is sort of law school 101. If a court doesn't have jurisdiction, that's it. They can't review the claim. It's the end of the story. But claim processing rules are rules that are really meant to help with the orderly progression of litigation. And so there are things that are quintessentially claims processing rules. And in reaching the conclusion that the exhaustion provision is a claim processing rule, the court reasoned that exhaustion provisions are those types of quintessentially claim processing rules. They're the kind of rules that are meant to help with orderly progression of litigation. And then the second rationale that they employed there is really a straightforward application of the test that always applies when you're looking at whether or not a rule is jurisdictional or a claims processing rule. And we call that test the clear statement test. And what that simply means is when you're looking at a statutory provision, Congress must clearly state its intention that the rule be jurisdictional. How does Congress do that? Well, sometimes it includes no court shall have jurisdiction. That's a clear statement about jurisdiction. Sometimes there are clues that you can pick up from context, and the government likes to point to the fact that, oh, it's in the jurisdictional section. We'll get to that in a second. But a rule can only be jurisdictional, and the Supreme Court has said that over the last 20 years, if the statement is very, very, it's unambiguous. So the threshold is quite high for clarity. And in this exhaustion provision context, as I mentioned before, the government was sort of saying it's jurisdictional. Look, it's in the jurisdictional provision of the INA. And the court rejected that. And they said, well, yeah, there's also some other provisions in the jurisdictional section of the INA that are clearly not jurisdictional rules. They're claim processing rules. For example, who do you name in a petition for a review? And who do you serve in a petition for review? And you have to attach the decision. These are all sort of not jurisdictional rules. They're just rules about how the litigation should move forward and what's necessary for the litigation. And importantly, in looking at 1252D, the Supreme Court looked specifically at the language that was used in that statutory provision and found that it was different from the other jurisdictional provisions in the same section that as I mentioned before, used words like no court shall have jurisdiction. And we're very clear about Congress's intent to make the rule jurisdictional. An interesting sort of side note on that first question is that the government tried to argue that that this issue sort of had been decided, that this provision had already been classified as jurisdictional by the Supreme Court's decision in INS versus Stone and Ken, which is a more recent decision. INS versus Stone was a case about the 30-day deadline to file a petition for review, and Ken was a case about the stay standard when you're filing a petition for review, what standard applies to get a judicial stay of removal. And Justice Jackson, who wrote the opinion for this court, said, those cases don't decide this issue. And moreover, you know, they predate our most recent last actually 2 decades of trying to correct lower courts' misuse of the term jurisdictional. So she kind of like, those don't really apply. And that's important to other petition for review litigation we won't get into, but it'll come up in the next case. And so I just want to mention that. As to the second question, with regard to whether the petitioner, Ms. Santos-Zacaria, had to have filed a motion to reconsider to satisfy the exhaustion provision, the issue in that case, or on that question was, is that a remedy, quote, as of right, that had to have been fulfilled? And the court determined that it wasn't a remedy, that it was available to non-citizens as of right, because it was a discretionary remedy. Now, I got to tell you, I don't love the Supreme Court's rationale as to the second question. I'll take the holding because we don't want to have to make people run out and file motions to reconsider in order to get judicial review of issues. But quite frankly, we don't love the fact that we have Justice Jackson sort of treating motions to reconsider as a very discretionary type of remedy. She relies on language in the regulations. She sort of suggests that the board doesn't have to adjudicate those motions if it doesn't want to. She likens it to, you know, whether or not a federal court has to take a permissive appeal. So it's not great. Both of the rationales in the court's decision is further expanded upon in our practice advisory, which is on our website, immigrationlitigation.org. We get into the details of the rationale, and the practice advisory is called Exhaustion of Administrative Remedies in a Petition for Review. But let's get to the key takeaways of this decision. If you could go to the next slide, please. On the first question presented, what does that actually mean? That the court found the exhaustion provision to be a claim processing rule. Well, that means that it's subject to waiver and forfeiture. And what that means is that if you file an opening brief in a petition for review and OIL fails to argue in the answering brief that that claim was exhausted before the BIA, they've sort of forfeited their ability to object and to make the argument that the issue was not raised to the agency below. And so if they don't raise it, the court can go on and address the issue that you raised in your opening brief. This holding reversed decisions from several circuits. And now it is uniform that it is a claim processing rule, and if OIL doesn't raise, doesn't object to your argument, then they have waived or forfeited that argument, and the court can go on to reach it. Now, really, really important to this analysis and to this case and to the takeaway from my going on and on about this case is the fact that this case is about exhaustion in a petition for review. It is about statutory exhaustion. It is not about issue exhaustion. Issue exhaustion is alive and well. And what is issue exhaustion? Well, issue exhaustion is the requirement that you have to raise things before the agency, before the BIA, or, before the IJ, and then you raise it to the BIA, but at least before the BIA, you have to raise an issue to the Board of Immigration Appeals to put them on notice when you're in removal proceedings of an issue of a problem with the case that you want to raise. Because if you don't give the agency an opportunity to correct the error, the Court of Appeals can say, you didn't exhaust that particular argument or that particular claim before the agency, and so we are not going to address it. And that's exactly what happened in this Ninth Circuit case on your screen. And it is something that has been happening for years. And people who litigate in the Court of Appeals know that when the government says this issue wasn't exhausted, you can't raise it, your response has to show that you actually raised the issue below, if it is something that the agency can address. And that's important. It has to be the type of issue that the agency can address. If you're trying to say the statute's unconstitutional, the regulation's unconstitutional, there's a little bit of an exception to that because there's no authority of the agency to sort of rule on constitutionality, for example. But for the most part, you just have to remember that the general rule of you have to raise every issue that you want to litigate is alive and well, and you should continue your practice of raising all those issues. All right, take away from the second question presented. On this point, the Supreme Court, in saying that you don't have to go back to the agency and file a motion to reconsider, is an abrogation of decisions from 4 courts of appeals. But while it is good that you don't have to go back to the agency to raise things that you say are wrong, it doesn't necessarily mean that you shouldn't, when you take a case where there's a final BIA decision, you shouldn't do that same analysis that you're always doing, which is, okay, this is a final decision. Is there a strategic reason to file a motion to reconsider or a motion to reopen? There are benefits to filing motions to reconsider. For example, it gives you another bite at the apple in terms of being able to seek a stay of removal. So maybe you're in the Fifth Circuit and you filed a petition for review and you don't know if you're going to get the stay, but if you file a motion to reconsider to the BIA, you can file an accompanying stay motion, and that might be helpful to your case. You also might have actually, the agency may have misapprehended a question of law or fact, and you want to raise that with the agency because you think you have a chance of getting it reversed. There's also a timeliness issue. Some circuits take a really long time. I know the BIA also takes a really long time, but no harm, no foul. If there's a reason to file a motion to reconsider, you should still do it, even though you may not be obligated to do it in order to get judicial review of an aspect of the board's initial decision. This decision, I think there's been a little confusion. It doesn't alter the standard of review of motions. When you're on a petition for review, the standard is still de novo for legal and constitutional claims, de novo for mixed questions of law, and factual questions are still reviewed for substantial evidence. Okay, so that's Santos-Zacaria. And let's move to the next, thank you. To the BIA's decision now, we're going to move to matter of Morales, which is also a case that involves claim processing rules and jurisdiction. And interestingly, this decision came down on May 5th of 2023, and the case I was just talking about, Santos-Zacaria, came down on May 11th. So matter of Morales actually comes down before Santos-Zacaria, before the Supreme Court says something in the immigration context about jurisdictional and claim processing rules. And keep that in mind. So Morales is a straightforward case of an attorney who filed a late notice of appeal of an IJ decision. And she and her, I don't know, however it happened, the appeal was filed by regular mail and not over night mail. And so it arrived after the deadline. And what does the BIA do? they reject that appeal as untimely, and the attorney files a motion to reconsider. And what happens is the BIA uses that motion to reconsider as an opportunity to address matter of Morales. And what it is really doing is addressing its earlier decision from 2006 in matter of Leodov. And in matter of Leodov, the board held basically that this deadline for filing an appeal is jurisdictional. Now, I have just been talking about how the Supreme Court has had decades of case law where it has been trying to correct the lower court's misuse of the term jurisdictional. And this is a classic example, because that 30-day deadline, when it was so held in matter of Leodov, was really never jurisdictional. And that deadline is embodied in a regulation, 8 CFR 1003.38b. And it was then and has always been a claim processing rule, because part of the reason for that is, remember, I had said that the Supreme Court said that exhaustion provisions are quintessentially claim processing rules. Well, deadlines have long been quintessentially claim processing rules. And there was no clear intention in the regulation that that deadline for filing a notice of appeal to the board should be treated as jurisdictional. And so the board overrules its prior decision in Leodov. And it says that as a claim processing rule, now it doesn't get into waiver and forfeiture because that really wouldn't make too much sense in this context. With deadlines, usually what we see is the court goes on to decide whether or not the deadline is mandatory or subject to equitable tolling. And so the board goes on in this instance to say equitable tolling applies, and it relies on the Second Circuit's decision in Adipo, in which the Second Circuit came right out and said that equitable tolling applies to this deadline. And equitable tolling, as many of you know, requires the showing of extraordinary circumstances that prevented the filing of the appeal, and that the non-citizen acted with due diligence in pursuing their rights. So the board in this case says tolling is not warranted because a mailing error is not an extraordinary circumstance, and that there was a lack of sufficient documentation of diligence. And I think what really happens here is that this motion to reconsider is sort of like, please reconsider this appeal. This attorney, it's unclear if the board was just, it seems to me like the board was just using this as an opportunity to announce that tolling applies. And it's unclear how much documentation was submitted. In fact, the board says not enough to show the standard for tolling, right? So to show that what happened with this mailing snafu, it could have been an extraordinary circumstance, but maybe not documented. And so, for example, what if the filing clerk that did all the BIA mailings, was out and the intern was covering and it was an honest mistake? It's not really extraordinary, but whatever it was, it had to have been documented. You needed declarations about what happened and why, something to give a good reason why this wouldn't happen all the time, while it was an out of the ordinary circumstance. But just sort of saying, oh, we put it in the wrong form of mailing, the board was like, that's not enough. And also to show that the person was acting diligently and doing everything they can. So the takeaway from this case is clearly that you should document and corroborate tolling claims. And if an appeal is late, you should go ahead and file a motion to accept that late appeal with the argument about tolling and documentation of tolling, and try to prove that it was an extraordinary circumstance and that the person is really acting diligently. With that, I will stop and pass it to the next presenter.
Hi there. All right, so thanks, Trina. So this case is a Fifth Circuit case from this year, Garcia Gonzalez v. Garland. I'll go through the facts a little bit because it's kind of a complicated procedural history, but basically it's an asylum withholding and cat case. The petitioner was an undocumented Honduran woman who came to the US with her son, fleeing the gangs. The gang members had attempted to recruit her son. They had kidnapped her nephew. One of these very sad, all too common stories. So the petitioner went into removal proceedings and wanted to apply for asylum withholding and cat. The IJ told the petitioner, as normal, that she would need to submit biometrics with the I-589, but her counsel messed up in some way and she missed the deadline. So she never submitted the biometrics, or she didn't submit the biometrics in time. So the IJ found her claims were abandoned and ordered the petitioner and her son removed, but also informed her that she might have a claim for ineffective assistance of counsel based on her lawyer's mistake. So then it gets a little bit complicated procedurally, but so she hired a second lawyer. The second lawyer appealed, but didn't argue the ineffective assistance issue. So the BIA affirmed the IJ. So then the petitioner wound up getting a third attorney, and the third attorney filed a motion to reopen, asserting ineffective assistance of counsel by both of the prior attorneys. So what happened at the BIA that time was that the BIA denied the motion, found that she couldn't show prejudice caused by the ineffective assistance of her prior counsel, and that gets into the merits of her asylum withholding and cat case. So there's three main issues, and I guess we'll go through those one by one. So the first one is relating to the PSG, the particular social group that the petitioner was seeking asylum withholding and cat as a member of. She said that it was her nuclear family, which makes sense. It was her son who had been threatened by the gang, so it was the PSG was family members of her son. And the BIA rejected that argument and the Fifth Circuit affirmed. The Fifth Circuit held that applicants must provide evidence, some sort of affirmative evidence of social distinction of your nuclear family in the country of origin. So basically, the issue was that the petitioner had just said that her PSG was her family, but hadn't provided any evidence about either why her own family or families in Honduras generally are socially distinct. And based on that, the Fifth Circuit said that this was not a PSG. She hadn't met her burden to prove it was a PSG. That's different from in many other circuits. So in the First, Fourth, and Ninth Circuits in particular, those have all said that a nuclear family is a classic PSG, classic example of a cognizable PSG, which at least strongly implies that you wouldn't need to submit any particular evidence that your family is socially distinct. Families in general are distinct by that reasoning. But in the Fifth Circuit, unfortunately, they've come to the opposite conclusion. So if you are arguing a PSG claim, your client's seeking asylum and withholding based on family as the particular social group, you'll need some evidence. The court is very vague, doesn't say what evidence, but some evidence, just suggesting that your client, their own family or families in general in that country are socially distinct. The second point from this case that came out of this case from the Fifth Circuit is about cat relief. So the petitioner was also seeking cat relief. She argued that she had made out a prima facie case for cat relief because in her I-589, she had said things like the Honduran police are infiltrated by gangs. She said that the BIA should have taken judicial notice of additional evidence that she didn't herself provide, but that the BIA could have found on its own about the situation in Honduras. And the Fifth Circuit rejected those arguments. So the Fifth Circuit held that the applicant's statement, her own statement, was insufficient evidence to show that the Honduran government would have acquiesced to her torture if she were deported there. So what we can glean from that, again, they're not very specific about what evidence you do need to provide, but just the client's own statements on the 589 won't be enough. You'll need to submit evidence that shows that police or other government officials in the client's country of origin would in fact acquiesce to torture. And it further held that The BIA may take judicial notice of documents like country conditions reports, but it's not obliged to do so. So, of course, best practice is to submit as much country conditions evidence as you can find and submit that as well. I think that's a good, or let me just finish this last point, if that's okay. So there's one last point here. So the point about sua sponte reopening. So the Fifth Circuit held that it has no jurisdiction over appeals of sua sponte denials of motions to reopen. So the petitioner had tried to argue that the BIA erred by not exercising its own authority, its inherent authority to reopen cases. And the Fifth Circuit held that it has no jurisdiction to even consider that issue at all. And that's an issue which I'll talk a little bit in a minute, but about where the petitioner's counsel hadn't really framed the issue in the right way. Okay, so Serena, if you want to give them the code now.
Yes, thank you so much, Aiden. So for all of our participants seeking the CLE code, it is AUTUMN, AUTUMN. I will post it in the chat. Thank you so much, Aiden. Go ahead. Thanks,
Serena. So just coming back to that last point about sua sponte reopening, the petitioner's counsel, it seems like, might have made a mistake in that they didn't argue that the ineffective assistance, that the motion to reopen should, because the motion to reopen was late, it had passed the deadline, so they might have thought that, oh, the BIA can only reopen using its sua sponte authority. That's not true. Even in the Fifth Circuit, despite its general issues, there is equitable tolling available for motions to reopen. So the pointers that I have here are, number one, just remember that evidence is necessary in the Fifth Circuit to show social distinction if the asserted PSG is based on the client's nuclear family. So some evidence, again, not clear what exactly, but some evidence showing that families or the client's family is a socially distinct group in that country. And then the second point, just remembering to, if your motion to reopen is late or if your client's already filed a motion to reopen, in the Fifth Circuit and also generally, the sua sponte route is, particularly in the Fifth Circuit, the sua sponte route is not going to get you anywhere on appeal because they say they don't have jurisdiction to consider it. But you can argue, like Trina was just talking about in the prior case, equitable tolling if there were circumstances that make it such that that explain why your client needs to file a second motion to reopen or a late motion to reopen. Can we go to the next slide? I have one more case. Great. Thank you. So this case is a BIA case, also about asylum withholding and CAT, matter of CGT. And I'll just go through the facts briefly. So the respondent here was a gay man from the Dominican Republic who was HIV positive, and he applied for asylum and withholding based on his fear of persecution due to his sexual orientation and his HIV status. And it was after the 1-year deadline. He testified before the IJ that his father had abused him when he was a child, based on assuming that his son was gay, but nobody reported it to the authorities at the time. So the IJ found that the respondent was a member of a cognizable PSG, particular social group. So that part of the asylum and withholding analysis was met. They actually found 2 cognizable PSGs, quote unquote, homosexual Dominican males and quote unquote Dominicans who are HIV positive. But the IJ denied asylum and withholding. The IJ said a bunch of things, the most outrageous of which was claiming that the respondent was unlikely to suffer future persecution in the Dominican Republic because no one in the Dominican Republic, other than his abusive father, knew he was gay. So the BIA on appeal corrected that mistake and came out with a pretty good opinion. So what the BIA did was it affirmed the denial of asylum, first of all, because of the 1-year bar, but it remanded for the IJ to reconsider the decision on withholding. And it held, the BIA held 3 things. So first, it held that the IJ had failed to fully consider the evidence in the record of the applicant's father making homophobic statements and insults. The Secondly, it held that the fact that the respondent hadn't reported the abuse to the police in the Dominican Republic was not determinative. So, generally, of course, that would help you show that you had been persecuted, but it's not required. And if the non-citizen can show that they had a good reason not to report it, or that reporting it would have been dangerous to them, would have just been useless, then that's not going to bar them from receiving withholding or asylum. And then the third thing, and I think there's good language in there about the fact that non-citizens are not required to hide aspects of their identity, like their sexual orientation, that are core aspects of their identity, to avoid future harm. So, of course, it was unreasonable for the IJ to demand that this person, if he were to be reported, just never tell anyone that he was gay. So that the BIA corrected that mistake. So the BIA remanded and directed the IJ to reconsider on all those grounds. So in terms of practice pointers for that one, in terms of past persecution, so what had happened was the IJ had made a finding that there was no nexus between the harm and the protected ground. So that maybe the respondent had been harmed, but that it didn't really consider the evidence in the record about why he had been harmed, the fact that it was based on the fact that people had been assuming he was gay. So this might be a good case to cite if that's the issue, if the issue is nexus. This case might also be good if your client is somebody who wasn't able to report what happened to them to authorities, if the police in their country of origin are, just wouldn't have helped them, or are working with the people who are persecuting them, or if the police are the people who are persecuting them. There's good language in there for that situation as well. And then lastly, if the client is somebody who could hypothetically avoid the harm by hiding something about themselves, like their sexual orientation, this is a good case to cite for the fact that, and hopefully IJs are not going to continue. I'm sure they will, but hopefully IJs will not continue saying that people don't qualify for asylum because nobody knows things about them that are nevertheless true. That's all I have on that one, so we can go to the next presenter.
Great. Thank you, Aiden. Thank you, Aiden. Sorry, I lost part of the screen for a minute. So I'm going to talk about this case, Casa Libre, Freedom House v. Mayorkas. It is another delay case, and it involves SIJ, and it was filed as a putative class action by 6 individuals and 6 organizations. And when they filed the case, they made essentially 2 claims. First, they claimed that USCIS was not following or not complying with the statutory 180-day mandate that required SIJ petitions to be adjudicated within that time frame. And that statutory site is Section 8 USC Section 1232 D2. And specifically, what the statute says is that SIJ petitions shall be adjudicated not later than 180 days after the date on which the application is filed. So the first claim was that USCIS just wasn't complying with that on a regular basis. There was a pattern in practice of the agency failing to comply with that. The second claim had to do with regulations that were adopted, I believe, if I'm remembering correctly, in 2022 to implement this. And that regulation is 8 CFR Section 204.11G. And it's 11G1. And 11G1 essentially says 2 things. First, it says that the 180-day clock won't even start until there's a submission of all required initial evidence. And it cross-references an earlier provision in the regulation, section 204.11D, D as in dog, that lays out what's required, what's the required initial evidence. And so USCIS has said in this regulation, the first thing it says is that the person doesn't submit all required initial evidence, then the clock has not started. The 180-day clock hasn't started. And with that, when that happens, USCIS, of course, has two choices. One, it can deny the application for failure to submit the required evidence, or two, it can issue an RFE. And in cases in which it issues an RFE, the clock will start at the point in time in which the individual submits that required initial evidence. So there's a delayed start to the clock. The second thing that this regulation, the 204.11 G1, says is that in cases in which the initial evidence was submitted, but USCIS believes that there's additional evidence that's required and sends out an RFE or a NOID in order to request that additional evidence, the clock is suspended. So it will have run up until, from the time that the petition is filed, up until the time when the USCIS issues the RFE or the NOID. It will have run, but then it will stop and be suspended until the point in time in which the individual submits the additional requested evidence. And once that is submitted, then the clock starts again at whatever point it left off. And the court in this case, so the plaintiffs challenged that as the second claim. The court called the first claim, the general delay claim, as a missed deadline or a routine delay claim. And they called this second claim the tolling provision claim. And there'll be there's references to both those claims throughout the decision, and we may talk about them. I may reference them again. The initially, about a year ago, the court addressed a motion to dismiss by the government and denied it in part. It did dismiss an equal protection claim that the plaintiffs had filed, but it did not dismiss these two claims. And both of these claims were brought under the Administrative Procedure Act, so it did not dismiss the APA claim. It then went on to, in May of this year, to decide the plaintiff's motion for class certification. And then in July of this year, it decided the plaintiff's motion for summary judgment. And I'm going to talk about both of those decisions. If you could go to the next slide, please. So the first was the class certification. And the plaintiff class and plaintiff class and the individual organizational plaintiffs sought certification for the plaintiffs on behalf of both claims, both the delayed certification, the delayed, what did I call it? The missed deadline or routine delay claim, and also the regulatory or the tolling provision claim. The court denied certification on the first of those claims, on the missed deadline claim or the routine delay claim. And the reasoning behind the court's decision was that that claim really was a claim under APA, the APA provision found in 5 U.S.C. section 7061. And that provision specifically has to do with unreasonable delay. And for unreasonable delay claims, the track factors that I talked about when I was talking about the Costa decision earlier come into play. And those factors are very individualized. For class certification, one of the requirements is that the plaintiffs have to show that there are common factual or legal issues that prevail in the case. And here the court said, because this claim really had to do with there would be individualized factors contributing to delay in each SIJ petitioner's case. It failed to satisfy the commonality requirement for class certification. And it also failed to there's similar kind of a need to show that the agency acted on a common basis with respect to the class as a whole for another part of the rule on class certification, which is Rule 23 in the Federal Rules of Civil Procedure. And so it found that that also wasn't met. And so for that reason, it denied that first claim. But significantly and importantly, it granted class certification on the regulatory claim, the claim that the tolling provisions violated the statute, essentially. The class that it's certified includes, this is a summary of the class, what you have here on your bullets, but includes, it's a national class, so it includes all SIJ petitioners with the exception of individuals who are class members in Galvez v. I think it's actually Jadoo now rather than Cuccinella. That is a class action that was certified in Washington State that also challenged the regulatory provisions that impacted the manner in which USCIS adjudicates these cases. So it challenged the same regulatory provisions as this case challenges. And because that's a certified class, and it was successful on some of those grounds, it's ongoing. But at any rate, because that is a certified class, this court carved that class out of the nationwide class. And so anybody who's a member of the Galvez class is not a member of Casa Libre, but other people around the country who satisfy the class definition, other SIJ petitioners are members of the class. And so the first is that it's this national class. Second, it is the SIJ petitioners who have or will submit an SIJ petition, whose petitions have not or were not and will not be adjudicated within 180 days. So it's both those who currently have not been adjudicated within 180 days and those who in the future will have filed one and that will not be adjudicated within 180 days. And that includes those individuals who were issued either an RFE or a NOID, causing a delay under the regulation. So it encompasses individuals whose cases were either stopped, the clock was stopped altogether under the regulation, or suspended for the submission of additional evidence under the regulation. Important to remember with respect to this class is that that any individual who satisfies the definition is automatically a member of the class. There are no steps that individual has to take to join the class. And so if you have a client who satisfies the class definition, obviously somebody outside of Washington State, then that person is a member of the class. Next slide, please. So the court then went on to look at the question of summary judgment, and it granted summary judgment to the plaintiff class with respect to the regulatory claim. So the plaintiff class moved for summary judgment on the basis of the regulatory claim, which the court granted, and it certified, and it found in favor of the class. It found specifically that the regulations tolling provisions violated the 180-day statute and the APA. It looked at the language of the statute. It said that language is very clear on its face. There's nothing about a suspension or tolling of the 180-day clock, and therefore it was impermissible for USCIS to to implement a tolling provision. And it based that both on the language of the statute as well as on APA section 706(8)(2), which talks about a provision being unlawful or violating a statute. The court then went on to look at, so it made a finding of that the regulation for tolling provisions were unlawful, but it then went on to look at whether or not to grant an injunction, which the plaintiffs had requested, and it declined to do so and instead issued only a declaratory judgment. And in doing so, it applied the normal factors for deciding whether or not to grant an injunction, and they include whether or not the harm to the individuals, the competing interest of the agency and the individuals, the public interest in a class being certified in the case, injunction being granted in the case. And the court primarily relied on the lack of significant or severe, what it called systematic, though maybe it meant systemic, I'm not sure, but it used the word systematic harm to the plaintiffs. And specifically, it said it relied on a couple of facts that had been presented as evidence in the case. One was that the average time frame for USCIS to adjudicate these SIJ petitions was 205 days. So that it found was not that significant a delay from the 180-day statutory timeline. It was 25 days longer than on average. It also looked at the fact that it was unlikely that SIJ petitioners would be deported while they were waiting for the petition to be adjudicated because of DHS policies in terms of not placing high priority for deportation of these individuals. And then it looked a little at the fact that some of the delay was caused by COVID, and there were other reasons. There had been a suspension of funding for a period of time for the USCIS office that adjudicated these petitions. So there were all these factors that came into play that said that there was little harm to the individual, and USCIS was in fact making strides in remedying the situation. It was pouring more resources into adjudicating these cases, and it was attempting at least to address the delay in the backlog. To what degree that is going to happen, who knows? Where that leaves individuals, so that was the holding with respect to the regulatory claims. It then went on to look at the summary judgment motion with respect to the other claim, the general claim that there was a pattern and practice of USCIS delaying adjudication of these claims, and it denied summary judgment for the plaintiffs in that case. And that again went back to the fact that it had found that that was an unreasonable delay claim essentially, and it found that that was not appropriate for summary judgment in this context without a class being certified. So on the one hand, it found that it wasn't appropriate to certify the class, and on the other, for that claim, and on the other hand, it said, because there was no class certified, it couldn't really give summary judgment to these organizational plaintiffs on this claim. But what's significant is that there is this existing summary judgment, declaratory judgment ruling with respect to the delay, a ruling which finds that that regulation is contrary to the 180-day statute. And so it's not an injunction. It doesn't prevent USCIS from continuing to follow its regulation, or it doesn't vacate that regulation or overturn it. But what it does do is give individuals a significant tool that they can use if they were to go into court on an individual basis for a case that is really unreasonably delayed. They can go in under the APA and say, hey, look, my case has been handled under the regulations, and the time has been suspended or tolled altogether, and that was improper. Here's the nationwide order that says that the USCIS is bound by that order, and I should get relief as an individual plaintiff. And so that's really the remedy that still exists for individuals. I will say, however, that the government filed an appeal of this just last week, and that appeal is pending at the Ninth Circuit. It filed an appeal just of the summary judgment, not of the class certification. That appeal is pending, and at this point, I did not see anything on PACER indicating that a stay had been issued. So I believe a declaratory judgment on summary judgment is still in effect, but you should definitely follow the case to see what happens with the appeal. And I think now turning it over to Chris.
Great, thank you, Mary, and good afternoon, everyone. Chris Rickard with the final case from the Supreme Court. Just to take a few minutes before our question period on a case that isn't necessarily one you'll be using day to day, but has enormous importance in terms of upholding the priorities that were issued by Secretary Mayorkas for the Biden administration in September 21. There were some iterations of prioritization before that, but at issue here was a 7-page document, September 21, about who in the undocumented population, ICE and CBP to some extent would prioritize enforcement proceedings against. And there were 3 categories which are familiar to you: national security, criminal, and recent border crossing. And the procedural posture of the case was that Texas and Louisiana, the states, decided to sue based on the fact that these priorities, as expressed in the memo, meant that there were fewer arrests than required by the INA. And they took a couple of provisions and said, look, it's mandatory under 1225 and 1231. Certain provisions say shall. And so there's an under-enforcement problem. The district court in Texas accepted the argument and vacated these civil enforcement priorities. There's a bit more to the memo than the prioritization of who to enforce immigration law against, but putting that to the side, the gravamen of the memo is about those 3 categories. And the Fifth Circuit declined to stay the district court's ruling, but the Supreme Court came in early, knowing that this case had great import for how DHS would operate in this administration. So they granted the rare cert before judgment. So the holding of the case was actually 8-1. There's a 5-person majority opinion that I'll focus on, but 8 of the justices thought that there was a standing problem. And there's a disagreement, which is fairly academic, over how to analyze standing. But the bottom line, and this is really the practice pointer here, is that about a month after this decision came down in June of this year, ICE declared in late July that the Mayorkas memo was restored, and also that OPLA's corresponding memo by Carrie Doyle, principal legal advisor at ICE, was in effect again as well. And so I think just the contours of it are worth looking at, because this will have impact as a precedent in different areas. And you all know that Texas and other states are very active litigants in the immigration sphere. What will this mean for other challenges to various policy choices by the administration and by the executive branch more broadly, is the more abstract and important part of the case for the future. But for the present, it would have been a very different world if those 2 memos continued either to be in limbo in terms of litigation by states about level of enforcement, or could have been struck down and really have, as the majority opinion mentioned by Justice Kavanaugh, the courts superintend prosecution system in the immigration realm. And the opinion by Justice Kavanaugh for 5 justices is brief. It really isn't anywhere near the length of a concurring opinion by Justice Gorsuch, another concurrence by Justice Barrett for herself, and the only dissenter was Justice Alito. And the real academic disagreement is, and it is interesting to see the justices' approach, is about the 5 taking a more compound approach. Different factors play into the conclusion that there's no standing, whereas the other 3 who would join in the ultimate holding that there's no standing prefer to ground it very firmly on redressability, that the courts aren't able to redress the claims made by these 2 states. So there is more in the majority opinion potentially for other situations, and I think the justices who declined to join the 5 would say that it's too multi-factor, lacks predictability, lacks bright line type applicability. But just to highlight, Justice Kavanaugh looked at historical precedent, put a lot of weight on a particular case from 1973 called Linda R.S., which is a child support case where there was alleged under-enforcement of child support enforcement. And I think the concurrence just says, look, these aren't binding in this particular situation. These are states suing, and here you're applying a precedent in a way that really is making new law rather than the straightforward application that the very short opinion, about 4 pages of analysis by Justice Kavanaugh, elucidates. So the other factors include the fact there's not a direct injury here. There's no one being prosecuted or being threatened with prosecution is what came out of Linda R.S. Obviously, the states are in a very different position. We should say that the costs argument, which was really how the states set this up, wasn't rejected entirely by the majority. And that's really the other point I want to make, is that in its analysis, it spends half the time saying what it wasn't deciding and categories of cases that could still be brought. And this has already played out in the DACA litigation, which was also very much a question of whether the state's costs could support litigation against a deferred action program. And Judge Hainan, as you all know, ruled again to strike down DACA and did not accept the idea that US v. Texas changed the standing analysis. He put a footnote that in the alternative, there's an allegation that is more specific by Texas about driver's license costs than the generalized costs in this enforcement priorities case, which are based on all sorts of social services and not as precise as Texas appears to want to portray its DACA standing. And the last point I'll make is just that what really is pertinent in terms of the right to sue that Congress can create, and that's another exceptional category that Justice Kavanaugh mentions. If Congress were to create a right to sue, for instance, that could be a different case here, is very pertinent in terms of the shutdown fight in Congress right now about the funding. Obviously, the exaction of negotiations will touch on immigration and border policy and funding, but H.R. 2, which is the House Republicans' bill on border security, contains provisions specifically authorizing states to sue on similar enforcement provisions. So obviously a reaction and an anticipation of future litigation of that exception. But I'll stop and we'll go to questions.
Yes, thank you all so much, Chris, Trina, Mary, and Aiden, for your excellent presentations on these cases and summaries. So yeah, with that, we had lots of great questions raised, and we do have a few minutes, so we'll just start going through them, and we'll kind of work our way backwards, starting with the Casa Libre litigation. So there were some questions. Let's see. One was answered on, is the government going to appeal? Which unfortunately, yes. But the another question is, how does one determine whether their SIJ application will or will not be adjudicated within 180 days if you have yet to file?
So I would say the short answer is that it probably will not be adjudicated within 180 days because the average processing is 205, and it has been increasing. That is actually the court pointed out, that's increased every year. There is a very good chance that it will not be adjudicated within 180 days. I think the bigger question is really it hopefully it won't, for unless that keeps extending. Hopefully currently filed cases will not pend a whole lot longer, but there may be cases out there that already have been pending for a very long time. And those are the cases people should think about whether they want to do some federal court action.
Great, thank you, Mary. And we'll also go back to US v. Texas. So this is a question for Chris. So does the standing ruling in this case mean that states will not be able to challenge the administration's enforcement policies, or are there other legal avenues through which states might try to bring claims?
I think that's really the key takeaway going forward, is how broad this opinion is. It's not quite a Bush v. Gore where it only applies to the particular situation, but there are an awful lot of caveats in terms of writing narrowly, even though the criticism of the majority of 5 by the concurring justices are that they're not providing particularity in terms of exactly how to define what an enforcement policy is. For instance, and maybe this is getting to the question somewhat, very much with reference to DACA, there's a passage in Justice Kavanaugh's opinion that says, oh, well, if this were enforcement decisions or refraining from prosecution or the initiation of removal proceedings that is tied to benefits, that's a different matter. And so where exactly is this fairly broad executive discretion on enforcement going to end? Where do other factors take it out of this particular ruling? He also accepts detention policy, which is very broad, and I think very much linked to some of the suits that are pending in terms of mandatory detention and what type of release and parole can ensue. So in short, this is a first word, not a last word on enforcement policy, but obviously this could have gone the other direction, and there could have been a situation where the courts were saying, you're not enforcing enough. The last thing I'll just say is that there's an abandonment exception to abandonment of enforcement. So the idea that laws could be on the books that are completely unenforced is also not decided. But what I think contributed to this seeming to be a very elementary type standing analysis from the majority's perspective is that, as Justice Kavanaugh explains, this would lead to an acceptance of the state's arguments would lead to challenges to under-enforcement of all sorts of laws. He gives the drug law, gun law, all sorts of examples. So we'll have to see how it plays out.
Thank you so much, Chris, for the helpful explanation. We'll jump around a little bit. So going back to CGT, or matter of CGT. So the question is, did they argue PSG based on an imputed sexual orientation? And if not, would that be a good argument to raise in cases like this?
Yeah, I think that's a good question. They didn't, at least it didn't appear in the BIA opinion. They were just arguing, our client is gay. I think it would have been a good idea to raise the imputed sexual orientation PSG, because that's sort of how they ran into their nexus problem, where they couldn't really show that anybody had known that he was a member of this group before he came out later on. So yeah, I think that's a good idea there.
Thanks, Aiden. And I believe one more question for you. So the question is, do you think there's a risk of other circuits following the Fifth Circuit and adopting their view of how to treat a nuclear family PSG, or is the trend still to follow the approach in the First, Fourth, and Ninth Circuits, where nuclear family PSG is pretty much accepted?
Yeah, I'm not aware of any other cases in other circuits, but I will say, so the Fifth Circuit opinion there did discuss sort of, and people might be familiar with the history of LEA 1 and the LEA 2 and LEA 3, and it's just been back and forth between the various administrations on what the rule is for family-based PSGs. And the Fifth Circuit kind of angrily pounded the table and said, where is our regulation? Because the Biden administration has been working on a regulation to change, to clarify what is and isn't a PSG, and that would include with respect to families. So it doesn't seem to me like that's coming anytime soon, but that is, I guess, something to be looking for down the road.
Great, thanks for the context. Thanks again, Aiden. And then we'll end on this last question. When making tolling claims under matter of moralis, do you think it's reasonable to frame tender age of a client as an extraordinary circumstance?
I mean, yes, and I think that the fact that the litigant is a minor has been held in other contexts to merit tolling in statutes of limitations, for example. And so I do think it could be an extraordinary circumstance, but I would advise people who are making that argument to look at tolling cases or cases about minors in their circuit outside of the immigration context, because you may find some helpful circuit court case law talking about the significance of being a minor on a deadline that has nothing to do with immigration, but would constitute circuit court precedent that could potentially be very helpful to making that claim. So in addition to making the argument through documentation, such as including the birth certificate and a declaration about what, why the child's age prevented him or her from filing a timely motion or appeal in this case. I do think that there is case law that can be developed significantly in this area.
All right, thank you so much, Trina. And I think with that, we have a couple of minutes left, so we'll just start wrapping up. And so just a note on CILA's pro bono platform. As a reminder, we host a pro bono platform called Pro Bono Matters for children facing deportation on our website, where our goal is to match more pro bono attorneys with organizations' cases so that more children and youth have legal representation. So please do check out our platform on the CILA website, where you can express interest in a case to get involved, or if you are at a nonprofit and are interested in posting children's cases that need pro bono representation, you can also email us at probono@abacila.org for more information. We want to thank you all so much, Trina, Mary, Chris, and Aiden, again for being here with us today and answering those questions and providing such helpful case summaries and practice pointers. And so with that, we will, again, just another plug for technical assistance. If you have questions on these cases or others that may affect your clients, please feel free to reach out to us. And with that, we are at the end of our webinar. So thank you again to everyone for joining us. Once again, we are always looking for feedback. So once we close out the Zoom webinar, you should have a pop-up feedback survey that'll open up, and please do take a minute to fill that out. And then for the CLE credit, for those seeking credit who have been on the webinar the entire time, we will be emailing you all the verification form that you can fill out and send back to us. So please do stay connected with CILA and NILA after this training. Check out our website, submit a TA request. And once again, thank you so much to our great speakers. And until next time, thank you all and have a great afternoon.